You've been told Roman law was the foundation of Western justice, that it established rights and protections that echo through modern legal systems. But Roman legal code had a specific category for conquered women. They weren't classified as human beings with rights. They were classified as res, which translates directly to things, objects to be inventoried alongside livestock and furniture. Right now, in the Justinian corpus and earlier Republican legal texts, there's a classification system so precise, so bureaucratically thorough, that it tracked conquered women through property registers using the exact same administrative language used for grain stores and military equipment. This wasn't metaphor. This wasn't cultural difference we can dismiss with relativism. This was legal machinery designed to transform human beings into commodities, and the implications of that classification system shaped 2,000 years of Western legal thought about women, property, and personhood in ways we're still confronting today. Here's what the legal texts actually say. Listen carefully. In the digest compiled under Justinian in 533 CE, but drawing from Republican-era jurists like Gaius and Ulpian, conquered populations are divided into categories. Free men became slaves, that's well documented, widely taught. But conquered women entered a different classification entirely. They became res mancipi if they possessed reproductive value, literally things requiring formal transfer, the same category as draft animals and Italian land. The legal procedure for acquiring a conquered woman was identical to purchasing an ox. 5 witnesses, a bronze scale, a ritual phrase confirming transfer of ownership. The law didn't distinguish between acquiring a woman and acquiring a plow. Both required the same ceremony. Both created the same legal relationship between owner and object. Read that again. The Roman state, this civilization we're told created the foundation for Western law, had administrative procedures that treated women's bodies as agricultural equipment. Now understand the machinery that made this classification functional. When Roman legions conquered territory, and we have extensive documentation from campaigns in Gaul, Iberia, the Eastern Mediterranean, the administrative process was standardized. First came the census. Military officials would count heads, divide populations, assess value. Men of military age were evaluated for slavery or execution. Children under a certain age were categorized separately. And women, specifically women between menarche and menopause, were assessed using criteria that appear repeatedly in administrative correspondence. Reproductive capacity, physical condition, existing children, skills like weaving or food preparation. These weren't abstract assessments. They determined monetary value in resale markets, which were legal, regulated, and generated tax revenue for the Roman state. We have price schedules. The Edict of Diocletian from 301 CE lists maximum prices for goods across the empire, and it includes human beings. A young woman of childbearing age, skilled in household tasks, was priced between 25,000 and 30,000 denarii. A farm ox cost 15,000. The legal code valued a reproductive woman at roughly twice the price of livestock, and this valuation was enforced through imperial decree across every province. When provincial governors sent inventory reports to Rome, conquered women appeared in the same ledgers as grain shipments. The administrative language is identical. Quantity, quality, condition, storage location, projected yield. Projected yield. Understand what that phrase means when applied to human beings. Roman agricultural manuals, Varro, Columella, Cato, discuss estate management with sections on managing slave populations, and they use the exact same analytical framework for both crops and people. Columella's De Re Rustica has a chapter on maximizing agricultural output that transitions seamlessly into discussion of slave reproduction, without changing terminology or methodology. He calculates the optimal ratio of women to men in slave populations. He discusses nutrition requirements during pregnancy the same way he discusses fertilizer application. He recommends incentives for women who produce multiple children, freedom after a certain number of births, using cost-benefit analysis identical to his calculations about whether to repair or replace farm equipment. This wasn't hidden, this wasn't shameful. This was mainstream administrative practice, taught to every Roman landowner, published in widely circulated agricultural manuals, and enforced through legal mechanisms that treated human reproduction as resource extraction. But here's where the classification system reveals its true purpose. The res designation wasn't just about property, it was about eliminating legal personhood entirely. When a woman was classified as res, she couldn't testify in court, she couldn't own property, she couldn't enter contracts, she couldn't refuse sexual contact because objects don't consent. And critically, any children she produced while classified as res were automatically raised themselves, born into the same legal category as their mother, regardless of paternity. Roman law was explicit on this point. Partus sequitur ventrem, the offspring follows the womb. If your mother was legally a thing, you were legally a thing. Perpetual inheritable object status transmitted through the maternal line. Now listen to what this meant in practice. When Roman forces conquered Carthage in 146 BCE, Polybius records that 50,000 women were taken during the final siege. 50,000. They were marched to coastal markets, registered in administrative logs, and sold across the Mediterranean. We have fragmentary records of these transactions, purchase receipts on papyrus from Egypt, inventory lists from Sicily, tax documents from Spain. The women appear as line items. Punic female, approximately 20 years, 2 children, weaving skill, 28,000 denarii. The children appear separately. Female child of Punic woman, approximately 5 years, 8,000 denarii. Families were inventoried like harvest yields and dispersed according to market demand. And Rome didn't just permit this, Rome taxed it. The vicesima libertatis, a 5% manumission tax, generated enormous revenue. Every time a slave was freed, the state collected. But here's the mechanism that made the system perpetually profitable. Women classified as reis could be freed, but their children born before manumission remained reis. So a woman might purchase her freedom after years of forced labor and forced reproduction, but her children, those projected yields, remained property. The administrative incentive was obvious. Encourage just enough manumission to generate tax revenue while ensuring the slave population reproduced itself across generations. The scale was staggering. Augustus's Res Gesti boasts that he settled over 300,000 soldiers in colonies across the empire. Those colonies required labor. Where did that labor come from? Conquest. When Dacia fell in 106 CE, Trajan's column depicts endless lines of prisoners being marched from the battlefield. Contemporary sources estimate 500,000 Dacians were enslaved. Half were women. They appear in administrative records from across the empire within months. Egypt, North Africa, Spain, Gaul. The Roman state had a logistics network sophisticated enough to distribute hundreds of thousands of human beings across thousands of miles, maintain registries tracking their locations and ownership, and tax every transaction in the process. This is the part historians often avoid confronting directly. The classification of women as reis wasn't a peripheral feature of Roman society. It was foundational to the imperial economy. Agricultural production depended on slave labor. Slave populations didn't reproduce at replacement rates under the brutal conditions of Roman estates. Mortality was too high, family formation too disrupted. So the system required constant replenishment through conquest, which meant the Roman military economic model required perpetual warfare, required conquered populations, required the legal machinery that transformed those populations into property. And the law evolved to make the system more efficient. Early Republican law had messier categories. Manus marriage gave husbands ownership of wives similar to ownership of slaves, but free Roman women retained some legal protections. By the late Republic and early Empire, jurists were actively refining the distinction between free women, limited personhood, restricted rights, and enslaved women, no personhood, total object status. Gaius's Institutes, the foundational legal textbook that trained Roman lawyers for centuries, dedicates extensive sections to these classifications. He's precise about the distinctions because the distinctions determined inheritance, property transfer, commercial transactions. You couldn't have a functioning economy without clear legal definitions of who was property and who wasn't. Read the legal commentary carefully. Notice the language. Ulpian discusses whether a master has legal liability if an enslaved woman dies during childbirth. His analysis treats it as a property damage question. Did the master exercise proper care of his reis, or did negligence destroy valuable property? The woman's suffering isn't mentioned. Her death matters only as economic loss. And the legal principle established, that masters must maintain their property in productive condition, became precedent that shaped Roman law for centuries. But here's what makes this classification system particularly insidious. It created legal justifications that survived the empire's fall. When medieval Europe rediscovered Roman law during the 12th century Renaissance, jurists absorbed these categories. The corpus iuris civilis became the foundation of continental legal education. Law students in Bologna, Paris, Oxford studied Gaius and Ulpian. They learned property law using texts that classified women as reis. They absorbed analytical frameworks that distinguished between persons and things, and those frameworks carried Roman assumptions about gender, reproduction, and ownership. You can trace it forward. Canon law absorbed Roman legal concepts. English common law borrowed from both. The Enlightenment legal theorists who shaped American and French revolutionary law, Blackstone, Montesquieu, Beccaria, were trained in Roman legal principles. When Blackstone wrote that by marriage, the husband and wife are one person in law, meaning the wife's legal existence was subsumed into her husband's, he was echoing Roman legal logic about women's relationship to property and personhood. The language changed, the underlying classification system persisted. Understand the through line. Roman law classified conquered women as res things. That classification was legally precise, administratively enforced, and economically foundational. It created precedents about female personhood, reproductive rights, and bodily autonomy that were absorbed into Western legal tradition and adapted rather than abandoned. When 19th-century American law classified enslaved women as property whose children inherited slave status through the maternal line, that was direct inheritance of Roman legal principle, partus sequitur ventrem, codified in Virginia law in 1662 and maintained until the 13th Amendment. The connections aren't subtle, they're documented. In law libraries across Europe and America, you can find legal treatises from the 1700s and 1800s citing Gaius and Ulpian as authorities on questions about women's property rights, married women's legal status, and the transmission of status from mother to child. Roman law was taught as the foundation of jurisprudence, which meant Roman assumptions about women as res were taught as foundational legal principles. And the human cost was incalculable. Every woman marched from Carthage or Dacia or Gaul and registered as res. Every child born to those women and classified as property from birth. Every generation of legal scholars who studied those classifications as neutral administrative categories rather than testimony to systematic dehumanization. The machinery perpetuated itself through education, through legal precedent, through the simple fact that once you've built an entire economic and legal system around certain classifications, dismantling those classifications threatens the system itself. This changes everything about how we understand Roman legal legacy. We teach Roman law as enlightened, as the origin of legal rights and due process. And it was, for Roman male citizens. But the same legal system that created rights for some required the elimination of personhood for others. The res classification wasn't a failure of Roman law. It was Roman law functioning exactly as designed, creating legally precise categories that enabled economic extraction while maintaining ideological justification through legal formality. The definitive truth is this. Rome classified conquered women as things because doing so was legally useful, economically profitable, and ideologically necessary for maintaining an imperial system that required constant conquest and population replenishment through enslavement. The classification wasn't metaphorical. It was technical legal terminology with specific juridical implications, enforced through courts, maintained in property registers, and transmitted across generations. And when we inherited Roman legal concepts, property law, contract law, family law, we inherited the assumptions built into those concepts, including assumptions about whose bodies counted as property and whose reproduction could be legally controlled. If you've learned anything from this investigation into how legal language shapes reality, hit that subscribe button on Mythbusting, because we're going to keep uncovering how systems of power use classification, language, and law to make exploitation appear rational, necessary, and just. The machinery is always visible if you read the sources carefully and refuse to look away from what they actually say. So what uncomfortable legal history should we investigate next? Drop your suggestions in the comments below.